I think that the biggest mistake made is that in this estate planning. We don't know what exactly was the intention, but that itself is a problem. So apart from the fact that this language was used, the fact that it was ambiguous even is all the worse. It could have at least been clearly stated what the intention was.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome. This is another episode of Life's Third Act. We're picking up with Tom Petty. You don't have to have watched part one, but I encourage you to go back and watch it. It does kind of establish a foundation for this, but it's not essential. So in this episode, we're going to talk about the latter part of his life and the estate planning issues and what occurred thereafter. So I hope you enjoy. The estate plan was set up to where there was one trustee, and that trustee was Dana. It was Tom's current wife. Among the beneficiaries were his daughters as well as his wife. So it's possible to have a trustee who is also a beneficiary. However, in occupying that role, there's this great susceptibility to charges of a breach of fiduciary duty or discriminatory behavior favoring one trustee over another. It just invites those allegations when you put somebody in that role, especially when you have stepmom and daughters. And this is what inspired this whole series of shows that we've been doing now for over a year, is this recurrent phenomenon in which the players, we change out the names, but the players are the same. So in this case, we had daughters who felt that they were not being treated fairly. And what really opened the box to a great risk of litigation was language that was a bit ambiguous at best. And the language said, shall have equal, quote unquote, equal participation regarding certain major decisions, a majority of decision-making matters that related to the assets and whatnot in the trust. So here we have, we'll assume all the important assets are in the trust. That, of course, includes the catalog, but it also includes anything rights relating to his name, his image, his likeness. Think of all the money that potentially is generated from an estate where people want to use his name, to use him to promote a product, to use his voice, to use a clip of the music just for promotional purposes. I mean, these things are ways that an artist's reputation are monetized in addition to the things we most readily think about. We most readily think about copyright and royalties from those things, which of course are important in themselves. So in this case, the daughters said, before long, after this was, a matter of fact, I think the suit, I believe, was filed in 2019. So the death was in 17. So it took a little over a year for these issues to fester. But I think it was inevitable that the daughters were going to allege that they were not being sufficiently included. They also did allege a breach of fiduciary duty because they accused Dana of diverting some assets from the trust into an entity that she created. I don't know that it tells her that. I'm going to assume that Dana has a side to this story too, and I know she does because she filed a counter petition.
Well, would it have been something smart for Dana to do as far as like the diverting the business opportunities from, it was Petty Unlimited LLC to Tom Petty Legacy LLC? You know, because I mean, you know, she had a lawyer. Maybe they advised her to do this because it would be a better way to hold on maybe to more money, maybe more tax-free, maybe to do more as a nonprofit kind of thing. Would that be something smart for someone to do, to change that?
You know, it could definitely have made sense. I mean, it's not uncommon for assets to be held in an LLC, but for liability purposes. So LLCs are a marvelous tool, just like, as a matter of fact, corporations. You commonly see sub-S's in some situation. People have heard of a sub-S corporation, and you have a C corporation. One of the primary incentives to create such things is that they insulate from liability the wealth or the other assets that the person may own. So it means that if anybody brings a lawsuit, all they can do is recover the contents of that entity. They can't spill beyond those walls of that entity. So it protects the assets that are not in the corporation or in the LLC. So the LLC is like, think of it as being similar to a corporation, has certain other advantages too. So the LLC, the way it's typically held is rather than having shareholders, you have members, and then you'll have a managing member. So the managing member runs the entity, and then the other owners are referred to also as members. And in this case, the way it's normally set up is it's not usually a wholly owned entity within the trust. It technically exists outside the trust. So the trustee is often set up as the managing member. So you can have owners outside the trust who own a part of the entity. And see, I don't know if there was some transaction relating to that. I think that would have been definitely inappropriate unless the children themselves were named as co-owners outside the entity. So the LLC, and we'll come to it in a few moments, where a similar, if not the same entity, was used later to resolve this case. But yeah, there could be perfectly good reasons for doing that. But clearly, there was a dispute mainly over the fact that it was Dana's position that this language did not override the fact that she was named trustee and the children were not. And that does suggest that when someone puts somebody in the name, puts the entity in the name of the trustee, I'll use an analogy that might help. Let's assume that you have a corporation and you have somebody who is made CEO of the corporation. And then you have somebody further down the line, a manager of some sort, or somebody within the organization. And there's something to the effect that they will have the phrase equal authority, equal participation in decisions. Most people would say, well, but clearly they're not the CEO. I mean, the CEO clearly is going to have final decisions. So equal participation doesn't mean equal decision-making authority. And that was Dana's position, which is a fair position. But others watching the show, I'm thinking, well, wait, now, why would he say equal participation? Well, what did participation mean? Did it mean actual decision authority, or did it mean that you get included equally in a discussion about what to do? But it's ultimately resolved by Dana or the trustee, whoever that is. The organization of the entity really, I would almost argue, would tend to trump unless you had other language that maybe in other documents in this litigation, which I've not seen. It could be that there was enough evidence there that the intention of the testator of the trustor or the testator, the person who does the estate planning, which is in this case Tom, the decisive question for the court is, in a case like this, what was the intention of the person who created these documents? Well, when it comes to wills, there's well-settled presumptions about intention. As a matter of fact, you can't overcome in many of those cases, even if you show that the person maybe didn't have this intention. They're rules that are so well settled over literally, and I mean literally 500 years of estate law and theory. So that's not so much true of trust. So in trust, the court really can start with a blank slate and say, well, what was the intention here? And before this ever went to trial, there was a settlement. And I think that's probably the best thing. And I think that probably Dana and her lawyers concluded, I'm speculating, concluded that they might not prevail. And as a result, a settlement was reached in which the assets, all of the assets of significance, were moved to this entity, which was Tom Petty Legacy. So I'm thinking it's the same entity, whether or not it is or not. I've read two different things in two different places. But what I saw most persuasively was a new entity was formed, and that all the assets were moved there, and that the three controlling members, I guess you'd say managing members, would be the two daughters as well as Dana.
So that would be equal, all three ladies, because like you were saying before, the wording of something where it was his wife was sole trustee and then the daughters were entitled. And when you say daughters, there's two of them. So would that mean then the wife had 50% and then the girls would split 50 at 25 each when it came to talking?
That's a good question. Actually, the way it's written, they each have equal authority. So it does look like it would be easy for them to gang up on Dana in terms of decisions. I suspect, though, that there's some language that gives her vote kind of like a supermajority in some cases. But anyway, it was resolved happily. And here's what I think is one of the most critical things. And I don't know if this existed before. Anybody who's watched this show knows that when you're dealing with intellectual property in this day and age, it's a very complicated subject. And not only that, it's a complicated thing to do. So the law's difficult and the management is difficult. You have multifunctional ways to capitalize on someone's reputation. So to be able to keep track of all those opportunities that involve streaming and digital and legacy media,
even AI. I mean,
AI, there you go. And that's going to be an issue, is to literally be able to recreate this person in a way that they appear to sing and do things as if they were alive. So yeah, all these reasons make it imperative that people turn to a management company, and there are a lot of them out there. The industry is called intellectual property management. Sometimes it's called artist management corporations. But there are different entities and there are prominent ones. And I was really glad to see that apparently part of this settlement was that they signed up with the company's called Red Light Management. And I wanted to check a little bit about them. And Red Light Management is hugely respected entity. And they're the ones who will take their orders doubtlessly from probably all three of them to some extent. I hope they have a management structure where they're not all three coming together to make decisions. That's going to be a mess. They really need to delegate this, and it's perfectly appropriate for a trustee to delegate this. And let's keep in mind that Dana is the trustee, so she has duties as a trustee that these daughters don't have. They didn't eradicate the trust. So I might have, to some extent, oversimplified this description a few minutes ago, because we still have Dana in a position where she simply must do certain things. And in a case like this, where you're a trustee of a trust and you own assets that are specialized assets, it's your duty, even often simply if you want to invest assets, to delegate it to a brokerage firm if it's just money. In these days, in order to get the right rate of return, the rules are so confusing that often simply large sums of money, it's a fiduciary duty to turn it over to an investment firm. And so you can imagine how true that is regarding something like intellectual property, which is like it is actively running a business, keeping track of all these threads simultaneously and the amount of money that can be generated. And the failure to pay attention to any one of these threads means that this company, not to mention a trustee who didn't properly delegate, could be sued for that. So if they miss an opportunity for an endorsement on, say, an Olympic event, for example, that would have been worldwide and would have generated hundreds of thousands of dollars, I mean, that could very well result in a finding of fiduciary mismanagement, a breach of fiduciary trust. So it's a lot of pressure, but if it is properly delegated, then the responsibility goes out to the experts, this third party that you've turned it over to. And that's the same reason for what I described a few moments ago, the incentive to turn over a pile of cash rather than go out and find stocks yourself and invest in them, heaven forbid. It makes far more sense to push it off to a very prominent, respected management firm. And it's appropriate delegation according to the rules governing trusts. And it doesn't mean that the trustee can go whistling down the road and not touch base with them. They still have duties. But at the end of the day, the most direct responsibility is with the party to whom it's delegated. And in this case, Red Light Management, let me tell you who they manage. It's impressive. Red Light Management, some of their notable clients currently include Dave Matthews Band, Chris Stapleton, Fish, Lionel Richie. Well, maybe his memory. I guess it's for his estate, I assume. Luke Bryan, Enrique.
These guys are still current. I mean, they're like still alive. So
Well, Lionel Richie's not, is he?
yeah, he is. And on American Idol, which starts again next month.
Are you
The
serious?
new season, yeah, with Carrie Underwood. Yeah.
Anyway, so you can tell how plugged
Luke
I am.
Bryan, he's on there too.
Okay, the Strokes. Have you heard of them?
I have heard of them. I couldn't tell you if they're still around. I think maybe some of them are.
Lady A.
Oh, yeah, they're
know-
still around. They're country.
That was Lady
I feel-
Antebellum.
Yeah.
They changed their name.
Yeah,
I
they
feel
did change
so
their name.
uninformed. Brandy Carlisle. I think
She's
I've heard
still
of that.
around. Well, and I'm sure so much of this, I mean, it's just like you're saying, it just is so much to be able to keep track of that you need this management team because you're talking AI, you're talking 50 years from now, they can go back and use Tom Petty's catalog for the Olympics, for to sell some brand of something. Or, I mean, I think they did this with Whitney Houston where they had like a hologram of her and they were having concerts. So obviously her family would be getting some sort of residuals for that or some management company.
Yeah.
You could
You're
be like
right.
Kiss,
So,
and they totally sold their rights to specifically
Yeah.
have an AI concert.
Yeah. They want to
Who
be
did?
remembered forever.
Kiss.
oh, really?
Yeah, they're making
Well-
Gene Simmons is selling that hard. It's going to be a whole phenomenon, according to him.
Forever.
Well, I mean, let's face it. The visual aspect of their show is probably considerably more impressive than the auditory. Of course, I'm not. I did listen to Kiss when I was young, but today I'm not that big a fan. But if you look at them in their totality, they were performance artists. They were artists that were at least as much about their stage performance as they were about the music
That is
itself.
truly
So,
about the show.
Yes.
Yeah, the show in the broadest sense.
Correct.
Yeah.
Yeah, I
So-
remember them most from their movie that they had. I couldn't tell you much about what they sang, but they were in that movie where they were at the carnival and they were on with Scooby Dooby Doo. That's how I know
Well,
them. I'm like, what?
See, that's the reason that we have you in this role, Sherry, is your cultural knowledge. But yeah, I don't know that much about them, but I will say that issues like you're describing, they're going to be huge. And so intellectual property will simply grow in complexity and importance. So let me kind of wrap up by making a couple of observations. We've kind of given you, our viewer, our listener, an overview of the events before the death of Tom Petty, the fact that we did have this dispute, and that dispute largely resulted from having apparently positioned two of the daughters to have to work in some way with their stepmom. I think that the biggest mistake made is that in this estate planning. We don't know what exactly was the intention, but that itself is a problem. So apart from the fact that this language was used, the fact that it was ambiguous even is all the worse. It could have at least been clearly stated what the intention was. The ambiguity resulted in litigation that in this case, fortunately, was settled in less than a year. It looks like from the date of the filing of the action, the time it was settled, it looks like it was less than a year, all occurring in 2019. That is extraordinary. As you know, Sherry, we normally see this to where, we're talking about this 5, 6, 7, a decade later.
Yeah, so it kind of gives me kind of the sense that there was some love there with their stepmother and the daughters. Perhaps that they, their love for dad, Tom Petty, was there. So maybe that's why they didn't want to argue for so long or string it out for so long. I mean, I know I love wearing rose-colored glasses. I can't help myself. And of course, it's too late to ask Tom what his intentions were. But you can't help but feel bad for him because, I mean, I'm impressed that he had all this in place to begin with. So many artists, you find that, if they lose their life at a young age, they didn't have all these things in place. And I know it's so important, especially with divorce rates the way they are. You don't want your family fighting over what you've left behind.
No, you don't. And even in this case, too, this was not an afterthought, this estate planning, because he had originally created the trust sometime in the early 2000s. And in 2014, there was a major revision. So he clearly thought about these things, and I understand his motivation. His motivation doubtlessly was to include all three of these, important women in his life, and he didn't want any of them to feel excluded. But it was just handled in an awkward way that I would think that one of the most important things that a lawyer serves relating to things such as this is their ability to put in enforceable language, in clear language, the intentions of their client. And I just think that this ambiguity invited the sort of conflict that we had here. Now, some may be watching this and think, okay, well, am I saying then that there should simply have been in charge Dana, or should all three have been trustees? And I would say that in this case, it could have been all Dana if in fact Tom was confident that she would do the right thing. I would say that's extraordinary, and I would say that would, as long as the children are beneficiaries, which they must be, of course, that's one of his primary goals, then it means there's going to be litigation, because even in the absence of this participation language, there'd still be allegations of breach of fiduciary duty because she did something in their opinion that she shouldn't have, or that she didn't do something that in their opinion she should have done. So I just think that as long as it was set up in a trust with one of the three, there would be conflict. And I think that all three of the three, there would be conflict. So my suggestion would have been that this is a classic scenario to have had a corporate trustee and an institutional trustee, they're called. Institutional trustees, they have a platoon of lawyers. They have people to assure that things are done correctly as they should. They're going to dot I's and cross T's. Some who are concerned about the personal piece, in that case, you could have in an advisory role, for example, some or all three of these, but there shouldn't be anything resembling a requirement to agree before an action can be taken. And I think that in this case, this would have been avoided with the right sort of corporate trustee. It would have put them all in the same position. So it's not as if any part of the three of the group is making the decisions that could harm the other part. So that would be my primary observation about this, was that error, which in this case worked itself out. I mean, this is about the best you could hope for, where you have a problem built in like this.
You mentioned institutional trustee. Is that something that, for lack of better words, a commoner can use, or is it something that's just kind of reserved for those, that lifestyles of the rich and famous kind of folks?
No. It's actually quite affordable. Anybody really who has north of $1 million in assets, and I know a lot of people are left out of that, but not as many as some of us might have thought a few years ago with inflation and whatnot. A lot of people are finding when they add up the value of their home, the value of their pension, whatever the residual value would be in their pension, other assets, life insurance. So when you add all this up, whether or not it's taxable, that's not the issue. The issue is whether or not it adds value to the estate, because that would result in money that would be managed by this third party. So yeah, I certainly at $1 million, and the more you go up, the cheaper it gets. I would say at $1 million, you're looking at maybe 1.5% would be the charge, maybe often 1%. So I can name off the top of my head several institutions that would at $1 million would be 1%. So even though some people would think 1% is a significant amount of money, it is. But when you think that what you get for that is a lot of expertise, and you have continuity, that means that if somebody dies or has an accident, is in the hospital, you're not suddenly without somebody to manage the assets. The institution will have longevity. And sure, institutions can die, but they don't die at the rate that human beings do. So I really am a big fan of it, especially for cases like this. And you can still, though, put in, as long as you have a tiebreaker authority on the part of the institutional trustee, you can have co-trustees. And that's, many institutions such as bank trust departments, they don't mind that as long as they're not putting themselves in a position to be unable to assure the right thing is done, and then they get sued too. So they do want to be assured that if there's conflict with a co-trustee, that they can get it resolved. And one way to do that, of course, is to give them tie-breaking authority. So that could have been done too, incidentally, was to put them, all three of them, as a co-trustee with the bank. That's a lot of co-trustees. So that would require some thought as to how you subdivide that authority. But it can be done. It is done.
And
So-
it would be saving those you leave behind any kind of reason to argue, and hopefully they could all get along that way. A little bit easier.
Yeah, and let me make one final point here too, Sherry, and that's that people have to realize that this scenario is like somebody leaving an ongoing business. So the business has to be run by somebody. And the danger of people who own businesses who will say they're willing to delegate, they're willing to put someone in charge of running the business, but they want to continue, as they should, to sit on, we'll call it the board of directors. So they still want to be in a position as to broad directional themes and broad issues, that they want to be able to have a voice in that and ultimately make some of those general decisions. That's perfectly appropriate. In this case, much of the argument that took place that really triggered this early conflict was decisions about what things they should do with these assets and how to protect the name of their loved one. They all three love Tom Petty. I'm convinced of
Yes.
that. And it turns out, though, that the daughters had different ideas than Dana about whether, for example, when they were going to issue an album, supposedly one of the issues was it could be Tom Petty or it could be Tom Petty and the Heartbreakers on this Best Hits album. And again, I'm sure this is getting distorted in the telling, but there was a dispute. The daughters felt that this should be all about Tom and less about the Heartbreakers in this anniversary album, I guess it was, that they were putting together. So those are the sorts of details that if you don't delegate it to a third party, like in this case, Red Light Management, who would report, remember, I'm not suggesting them as a trustee so the viewers are clear. The trustee will be an institution such as a bank, or there are simply trust companies. They would in turn subcontract, and they would delegate this authority to Red Light Management. So Red Light Management, you want to make all these decisions. You do not want these three women who love Tom, each of them getting their hands in decisions on a day-to-day basis, because it's going to be a mess. And I hope that the settlement that they reached in 2019 and dismissed this lawsuit, I hope that settlement was one in which they each committed that they would let Red Light Management make all the day-to-day operational decisions, and they would reserve their decisions for certain very broad directional questions relating to the business. But it shouldn't be one in which a board member would ever reach into operational decisions, because that's going to be a further mess. The future will tell us if there's problems going forward. Well, this is pretty interesting, do you think, Sherry?
Think so. I think this is one, because there's not as much drama, that maybe more people can be like, well, he seems like a regular kind of guy,
Yeah, I mean, he's a positive role model.
Yes.
I mean, he really is. And it's a tragedy how his life ends at 66. Did we find out if he had quit smoking?
He didn't, no.
Really? He smoked to the end?
Yep.
Huh. Okay. Well, look, all of us have weaknesses. But anyway, he really was a role model in so many ways. And by all evidence, he was a good husband and a good father. So, good for him that he did planning, and it wasn't perfect, but, we can't expect our lives and all of our things to go perfectly. A lot of things did go perfectly for Tom Petty.
Yeah, he left behind such great music for us all to enjoy forevermore.
Okay, with that, this has been another episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.